Hello everybody, welcome to Legal Talks by Desi Qanoon. This is a show about law and we will discuss cases, concepts of law, principles of law and other things related to law. Cutting the chase, let us move on to the topic that we intend to discuss today. Today we will discuss a recent judicial pronouncement by the Honorable Supreme Court of India, Pradeep Kumar Sonthalia versus Dhiraj Prasad Sahu and another. What is this case about? This case is about a very interesting question related to election law. Imagine a situation that a member of Legislative Assembly, that is an MLA, has to cast his vote in an election to the Rajya Sabha. Now he casts his vote at 9:15 a.m. on the date of the election, and subsequently at 2:30 p.m. on the very same day, that person is convicted and sentenced by a competent court of law in a criminal case. Now would his vote become invalid? He had casted his vote in the morning and he got convicted in the afternoon. Would his vote become invalid? That is the question that has been answered in this case. Now, what are the important provisions of law in this case? This case involves a reading of Article 190, 191 of the Constitution of India and Section 8, Subsection 3 of the Representation of the People Act 1951. Now, what is Section 8 of the Representation of the People Act 1951? Now, we will read only Section 8, Subsection 3. A person convicted of any offence and sentenced to imprisonment for not less than 2 years, other than any offence referred to in subsection 1 or subsection 2, shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. So what is the meaning of this section? This section intends to state that any person who is convicted of any offense and he is sentenced to imprisonment for not less than 2 years, that person would be disqualified from contesting in the elections. And now let us move on to Article 191 of the Constitution of India. Now, this article talks about disqualifications for membership of the members of Legislative Assembly or the Legislative Councils of the state. So we do not need to read the entire provision. We just need to read Article 198 1E of this provision. So what does this provision say? This provision says that a person shall be disqualified if he is so disqualified by or under any law made by the parliament. So suppose if a person is convicted by any court of law, then that person would entail disqualification under Section 8 of the Representation of the People Act 1951. That is what we studied in the earlier provision. Now, let us move on to Article 190 of the Constitution of India. Now, this provision talks about vacation of seats. And in this provision, the important provision is Article 190, Clause 3, Subclause A. Now, what does it state? It states that a person will have to vacate his seat if he or she becomes subject to any of the disqualifications mentioned in clause 1 or 2 of Article 191. So basically, if a person is disqualified under Article 191 that we had read earlier, then that person would have to vacate his or her seat. So these are the important provisions. Now let us, for a brief moment, consider the important case laws that have been discussed in this case. There are two cases. We'll come to them later and we'll discuss them at length. But in brief, these two cases are Jyoti Basu versus Devi Goshal and Pashupathinat Singh versus Harihar Prasad Singh. In Jyoti Basu versus Devi Goshal, it was stated that an election dispute lies in a special jurisdiction and hence it has to be exercised without importing concepts familiar to common law in equity unless they are imagined in the statute itself. So, the court meant to say that we do not have to restrict ourselves to the general principles of law, and in a election disputes the electoral law takes the front seat and all the general law take the back seat. So any election dispute has to be decided keeping in mind the electoral laws. And now let us move on to the other case, that is Pashupatinath Singh versus Harihar Prasad Singh. Now in this case it was stated that if a statute uses the words on the date, then they should be taken to mean on the whole of the day. Suppose if we are talking about 20th of December, then it would mean the whole of the day, and we should not take into consideration the fractions of the day, since it would lead to a great confusion. Suppose a person has to fill a form on 20th of December and that person comes to the government office at 11:55 p.m. Now would that office be open for that person? That would be a very, very confusing situation for everybody. So in this regard, this case said that wherever the statute uses the words on the date, it should be taken to mean on the whole of the day, and that law disregards as far as possible fractions of the day. Now let us discuss the main legal principles that have been discussed in this case and the crux of the legal reasoning of the Supreme Court. Now the Supreme Court said that the event which causes the disqualification under Article 191E read with Section 8 Subsection 3 is a conviction of a person for any of these specified offences, and the consequence of such disqualification is that the seat becomes vacant. So obviously an MLA who has become disqualified and whose seat has become vacant is not entitled to cast his vote for electing a representative from his state under Article 80 sub clause 4, which talks about election to the Rajya Sabha. So a disqualified person cannot vote. That is what the Supreme Court meant to say. Further, the court harmoniously construed the case of Pashupatinath Singh in relation to the facts of the present case and said that if the date on which scrutiny was taken up can be held to have ended at the time when the event of scrutiny was taken up, we should, by the very same logic, hold that the date of commencement of an event, such as conviction, and the consequent disqualification should also begin only from the time when the event happened. Now, why did the Supreme Court said so? The Supreme Court further explained its reasoning and it held that to hold that an MLA stood disqualified even before he gets convicted would grossly violate his substantive right to be treated as innocent until proven guilty, and there is no precedent to suggest that a conviction may take effect even a minute prior to itself. To fortify this observation, the court relied upon the dictionary meaning of the word date and observed that date could also be used to denote a point of time. So it's not the whole of the day, as was said in the Pashupati case. But here we'll also have to harmoniously construe with the facts of the present case, and it could also mean that date is used to denote a point of time as well. So, further, the court acknowledged that there is a legislative silence and observed that legislative silences create spaces for creativity. And between interstices of legislative spaces and silences, the law is shaped by the robust application of common sense. Therefore, it was opined by the court that conviction is the cause and this disqualification is the consequence. A consequence can never precede the cause. So basically, the court used common sense here. Because there is a legislative vacuum, such a situation had never arisen before, that a person casted his vote at 9:15 a.m. in the morning and got convicted at 2:30 p.m. And the court also got influenced by this court by Justice Oliver Wendell Holmes Jr. in Henry R. Town versus Mark Eisner. It is a very beautiful quote. A word is not a crystal, transparent and unchanged. It is the skin of a living, though, and may vary greatly in color and content according to the circumstances and tie in which it is used. So, what Justice Oliver Wendell Holmes meant to say was that we must take the context into account whenever we interpret any particular word or any particular provision of law. So, finally, the court held that the vote cast by the returning candidate at 9:15 a.m. was rightly treated as a valid vote, and to hold otherwise would mean that the returning officer ought to have foresighted about the outcome of a criminal case, and this would result into creating endless confusion and needless chaos. So the vote was treated as valid. I totally agree with the reasoning of the court, and the court did acknowledge that there existed a legislative vacuum and it used the interpretative tools at its disposal, that is, the case laws, the dictionary that it perused, in a magnificent and a clever manner to remove the absurdity and conundrum that could have taken place in the times to come. Such a situation can also arise in the future. So, the court set this controversy to rest. The reasoning of the judgment is in itself crystal clear that a person cannot know what is about to happen in the future, and hence any such expectation is farcical. So, I hope you have enjoyed this show and you have enjoyed the this case law and the reasoning of this case law. So, thank you very much. Please subscribe and follow us on YouTube, iTunes, Twitter, LinkedIn, Discord, Telegram, and Facebook. Stay tuned. We'll come back soon. Thank you.